A huge win for gun rights at the Supreme Court, and Tom Gresham is here to talk about it. Gun Talk Nation is brought to you by Ballistic Advantage, Franklin Armory, Hodgdon, the Gunpowder People, and by EOTECH, Advantage U. Welcome into Gun Talk Nation. So big news, big news out of the Supreme Court. Lots of stuff going on for gun rights this week. So welcoming in our expert, Tom Gresham. Welcome in.
It's good to be here. It is huge news. And I think, honestly, Ryan, I think a lot of the media doesn't understand what just happened with the Supreme Court decision. They're kind of focusing on the concealed carry aspect, which is a big thing, but missing the even bigger news.
Yeah. What's the bigger news?
Well, the bigger news is the Supreme Court, as I explained to somebody, said they were like Sherman marching to the sea, doing a scorched earth march through the lower court decisions. Go back to 2008 with the Heller decision, 2010, the McDonald decision. And ever since then, the lower courts have been saying, yeah, there's Heller, and yeah, there's a Second Amendment, but we have to balance that out with the interest of the government to do whatever the government wants to do. So yes, we agree there's a Second Amendment right, but we're going to offset that. And yesterday, the Supreme Court said, knock it off, kids. No more of that. There is no two-step deal anymore, because that's what the courts have been doing.
Maybe we should kind of explain the case too, right? So just in case someone's listening, they go, I don't know what we're talking about.
All right, good point. All right, let's start at the beginning. This is the New York State Rifle and Pistol Association versus Bruen case. It made it to the Supreme Court. What it did is it challenged New York's scheme for issuing, or really not issuing, concealed carry permits. In New York, it's not enough to meet the criteria. You have to then prove that you have good cause or proper cause to get a concealed carry permit. In other words, you have to go to the police and say, this is why I need it. And they say, no, you don't. You say, well, but I'm a nurse that works late at night and have to come home through a bad part of town. Not good enough. Is there a specific recurring threat to your life? If not, you don't get a permit. Except,
yeah, and so there's really it's wide open for interpretation here, and New York will say we have concealed carry permits. We're not saying that you can't exercise your Second Amendment right, except that basically almost no one gets a permit, and
unless you're a celebrity, or you pay them $10,000 or give them a Rolex, which we found out it was happening with some of these issuing agencies, police officers, of course.
Yeah. And then it's like, well, tell us your reason, and then we'll tell you if we think that reason is good.
Right. And so what the Supreme Court said yesterday, as we're talking in the Bruen case, we just call it the Bruen case, was no other constitutional right, and no other right do we require people to seek the approval of a government officer before you could actually exercise that right. Would never dream of doing that for the First Amendment.
That's exactly what it said in the decision, which was one of the statements that we're seeing everybody repeating, because it's such a strong statement of what this decision's all about.
Well, exactly right. And so what they said was, okay, you cannot require this strange proper cause. What the Supreme Court said was, look, what you're saying is you have to be extraordinary to be able to exercise the Second Amendment right. You can't just be a regular person who wants to defend yourself. Under the New York scheme, you have to be extraordinary. And that's the opposite of what our rights are. That's what our constitutional rights are. They are for everyone. So you have to do away with that. So this is going to wipe out this proper cause or good cause requirement in 7 or 8 states: New York, New Jersey, Massachusetts, California, Hawaii, some others. They're going to go to shall issue. Now, we know they're going to put as many burdens and obstacles in the way as they can. And this is going to open the floodgates for lots of lawsuits, and it will be a process. But I guess we probably should say, look, for anybody who's listening to this or watching this, this does not overrule these laws right now. You cannot today just go put on a gun and carry a concealed gun. You can't do that. That's not the law. Wait till the process works its way through the courts, and they will have to change the law, and then you'll know what the law is. And it will be shall issue, but they'll put, training requirements, waiting periods, background checks, some other stuff, but it will be doable because right now it is literally undoable for most people.
Yeah, I mean, and what's funny about this is the responses from President Biden and the governor of New York.
Oh my
right?
gosh, she's such a loon. She lost her mind over it. She just really did. It's like, okay, Governor, you really don't understand. And part of it, Ryan, is that they truly don't believe that this is a real right. At their core, they think, no, there really is no right to own a gun. There certainly is no right to carry a gun. And the Supreme Court saying, no, look, if you read it, it says keep and bear. Keep means you get to own it. Bear means you get to carry it. And it doesn't mean you get to carry it from your living room to your bedroom. It's not just in your home. It means in public. That's what it means. And then so that was the concealed carry part. And that was good and that was important. But honestly, that's like 3% of the importance of this case yesterday. The big deal is the Supreme Court. You know how we've always talked about levels of scrutiny. We hope that they have, there's rational basis and intermediate scrutiny and strict scrutiny. And we kept saying we really would like it for it to be strict scrutiny. They didn't do strict scrutiny. They went a step above that, which never existed before. They said no scrutiny at all. There is no scrutiny. They said, look, scrutiny means we have to balance this versus that. He said, no more balancing, no more two-step, simply this. Is this something that's covered by the Second Amendment? Then the person has the right to do it. Yeah. Done. And they said,
huge.
No more levels of scrutiny. It's bigger than we ever would have hoped for. And now the question is, what does that mean? Well, we can guess. I think we know some of the things, but certainly it's already, as of like right now, cases are being filed in courts all around the country on the basis of this decision saying, okay, we're going to overturn your so-called assault weapons ban because you can't ban guns that are in common use. Those are all going to go away. That's going to happen. Don't know what's going to happen with magazine capacity limits. Possibly those go away. An awful lot of existing laws are going to go away now.
It's just an amazing, huge slam dunk. But Biden said he was very disappointed in the decision to uphold rights. And the governor said, this is going to put New Yorkers' safety at risk. And I'm going, Governor, and I know it's totally dishonest, but you're going, there are 41, 42, 43 states where concealed carry is legal and common, and you've got 25 or 26 where you don't even have to have a permit. Mm-hmm. And people aren't, just blood and running the streets, shootouts everywhere in those states either.
Well, the thing here is, this is going to unleash all sorts of murder and mayhem. And the question that, in fact, I sent a note this morning to a reporter who was writing about this. I said, the question for you to ask, your follow-up question when they say this is, where have concealed carry permit holders been a problem? Not anybody else, not people who are already committing murder, not people who are already breaking the law. Show me where concealed carry permit holders have been a problem, because it doesn't exist. There's nowhere. In fact, I remember the Florida Department of Law Enforcement did a study, and they said their concealed carry permit holders commit crime at a rate of about 1% of that of the general public. 1%. 1%. The most law-abiding group of people we can identify, the people who have carry permits. Well, let's see. If you have it, now that's not counting constitutional carry, but if you have to get a permit, photograph, fingerprint, trained, background check, who knows what else, depends on the state. It's pretty much a group of state certified good guys and gals.
So I know that the states, the 7 or 8 states that are going to have to change their laws from may issue to shall issue are going to come up with some things. After this quick break, I want to talk about what we might encounter and how we combat that. Franklin Armory is your trusted source for binary trigger systems, and their latest one is the GS 173. This is a kit for Glock Model 17s, and the kit is for Gen 3s. It comes with the slide, which is optics cut, and the trigger, an upgraded trigger. But the big deal is It's binary. That means every time you pull the trigger, it shoots. And when you release the trigger, it shoots. But it also has a selector switch on it, so you can actually cancel that second shot. It's a pretty cool little system, a huge upgrade for any Glock. Very fun to shoot. You can shop freedom and innovation at franklinarmory.com. Ballistic Advantage, they manufacture quality rifle barrels, uppers, lowers, and other firearm components for your next AR build. And they have kind of some special stuff like the Hansen Profile, which is really an interesting, well thought out barrel for AR-15s. You can find out more about Ballistic Advantage barrels and all the other parts at ballisticadvantage.com. Ruger's Light Rack LCP2 is a low recoil pistol, ideal for training or concealed carry. Comfortable shoot, regardless of your hand size or strength. The Light Rack LCP2 is all about being easy to run the slide. And we like easy, right? So check them out, Ruger.com. So I was thinking about Illinois. Illinois has been one of those weird states that has been difficult. You have the FOID card. It's the tail that wags the dog. Chicago and then the rest of the state, especially the southern half, is just very much agriculture and all that type of thing. Now, we had McDonald.
Miller first and then McDonald.
And McDonald was in Illinois, right?
McDonald was Illinois, and McDonald was basically established that the Second Amendment is an incorporated right and it applies to the states.
Okay.
That was the big deal there.
You still have people, states requiring a certain amount of training or all these different hoops that you have to jump through to get your permit. Is that like saying you have to be able to read to vote?
A little bit. Yeah, but that's not going to go away. That was actually covered in this Bruen decision yesterday, that states can have these requirements for training and background check and mental health records check. I hope it's not like you have to go to a psychiatrist. They have to say, oh yeah, this person's never going to commit a crime or be a problem. Probably not going to get a doctor to say that, but a mental background check. Have you ever been adjudicated? Have you ever been, ruled to be officially a wingnut loony?
Right.
So we got that. That's going to remain. And some of the more strict ones they're going to try to put in will be challenged in court. That's a given. I did love the meme, or probably a tweet comeback at the New York governor when she was complaining about this decision. And somebody just very succinctly said, I am so sorry that the Constitution happened to you.
Yeah, well, they kind of want to pick and choose. Well, they also said this was a violation of the 14th Amendment, not just the Second Amendment.
Right. And so it works on two different levels. And I would encourage anybody, it's available online. I've been reading it and it's not difficult to read. You think, oh, it's going to be a long legal deal. Well, it's long, but it's easy to read it. Clarence Thomas wrote this. That was the best we could have hoped for because he is brilliant at this. This is his high watermark. And interestingly enough, the case that he wrote was issued on his birthday yesterday.
Yesterday, it was his birthday.
Yes, it's perfect. Brilliant. And I can only think that Justice Antonin Scalia, who wrote Heller, is somewhere in heaven saying, well, it's a bad dang time,
Yeah, he's probably enjoying this. So if someone is in a state, New Jersey or New York or something like that, I mean, what are their next steps for this?
Keep informed is the main thing. Get plugged in. It's like we've always talked about.
Mm-hmm.
And how do you do that? Certainly you can belong to some of the national groups, but really they're not going to be telling you everything that's going on in your state. You need to belong to whatever your state organization is, or maybe more than one. And unfortunately, we never used to have to say this, but be careful because there are some bogus state groups that have popped up. There's a few people that have started creating bogus state groups everywhere, and they sound good. They look good because they know how to do a website. Look at them carefully. How long have they been around? If they've only been around for 2 or 3 years, I would be careful. But yeah, get plugged into your state groups because they're going to tell you what's going on. And frankly, they're going to tell you if you need to take some kind of action, like contacting legislators or the agency that's going to be putting out the regulations. Essentially, it's that old deal of, stand up, speak up, show up. Tell me when, tell me where.
So what's also kind of weird is this week we have that big win for gun rights, but then you also have some states, some people losing some rights. You have Washington magazine capacity bans going into effect. You'll have Rhode Island signing into law some really horrendous gun bills.
Which
give us an update on that side.
Very likely, a lot of those are going to get overturned on the basis of the Bruen decision.
Wow.
I mean, if you're banning, first of all, in Heller, they said you cannot ban guns that are in common use, period. In the Bruen decision yesterday, they reaffirmed that. They said, look, we said you cannot ban guns that are in common use. And they went even further than that because, the people say, well, the Second Amendment basically guarantees you can own a musket, which
right.
is right. As you're putting this on the internet, exercising your First Amendment rights on the internet. So the court yesterday said, no, this applies to modern guns and you cannot ban guns that are in common use. Therefore, I would think, not being a lawyer, but I think what we're going to find is the courts are going to say, yeah, if you can't ban guns in common use, you cannot ban AR-15s, you cannot ban semi-automatic rifles, you cannot ban handguns. All those are in common use. Whether that's going to extend to standard capacity magazines, with a hold more than 10 rounds, we'll have to figure that out. The lawyers will fight that out, but they are, as we speak, there are cases being filed and refiled and going back and saying, all right, Ninth Circuit, you ruled this, but on the basis of the Supreme Court's decision, we have to go back and take a look at it because clearly you were wrong on this.
Well, going back to the magazines thing, 30-round mags for ARs are the most in common use magazine for ARs. Good luck trying to find a 10-round or a 20-round. Yes, you can, but if you just look up AR mags, they're pretty much all going to be 30-round mags.
There's another element here, small element that the folks at Knife Rights pointed out. Says, the Second Amendment applies to knives too. It doesn't say guns; it says arms. And some people are saying, well, we'll just start banning ammunition. Nope, sorry, ammunition falls under the category of arms. Can't do that either. So we have states that have different kind of weird laws about knives. Probably some of those are going to start falling as well. This is going to be fascinating. I think it's a full employment act for lawyers.
Oh gosh, always the lawyers seem to do well with all of this stuff. They're the ones that benefit no matter what.
Okay, weird side story. Paul Clement argued this case for the New York State Rifle and Pistol Association, an excellent attorney working for a big law firm. As soon as he won, they told him, you got to get rid of all your Second Amendment cases and all your Second Amendment clients. And he said, well, bye. So he got canceled after winning a 6-3 decision at the Supreme Court.
He got fired from his firm.
Correct.
Wow.
Yeah.
That's crazy.
Isn't that something?
That, and it goes to, instead of like upholding the Constitution and they're so ingrained in their beliefs and their biases that they're just not happy that the outcome was that.
Right. It's to the point where they say, well, we don't want to be associated with freedom. We don't want to be associated with your kind of freedom.
So if he had lost, would they say, though, cool, we'll keep you employed?
Maybe, that's a weird deal. I think, okay, you just won a major landmark case in front of the Supreme Court. You need to get out of here.
Right.
So weird.
Wow, that's amazing. Well, so after this quick break, I want to talk about what's going on in Congress and the Senate right now, because they're trying some stuff too. The SAUER P320X10 combines the X series features with 10 millimeter. Yes, a 10 millimeter pistol new from SIG. The X series is a X series grip module, a deep trigger undercut, extended beaver tail, and aggressive stippling for a high grip to manage recoil. And they actually really didn't just chamber a 320 in 10. They redesigned the grip to make it fit your hand and make it fit that 10 millimeter cartridge and the mags. Comes with two 15-round mags. It's optics ready. You can find out more at sigsauer.com. EOTECH offers a wide variety of optics from holographic sights and magnifiers to rifle scopes, thermal and night vision, and hybrid and pistol sights. They actually have a new one called the E-Flex. It's the mini reflex pistol sight. It enhances your shooting performance with durable aluminum housing, top loading battery, large glass lens, and incredible clarity. You can find out more about the E-Flex and all the EOTECH and Voodoo products at eotechinc.com. Springfield Armory's new XDM Elite 4.5-inch OSP handgun in 10 millimeter. So it's a smaller 10, maybe a little bit easier to carry, especially if you're walking around the woods for a long time. 16+1 capacity, has the matched enhanced trigger assembly. That's a flat face trigger, crisp break, and it has integral over travel stop, optics cut on the slide, ready for your red dot. Springfield-armory.com. So as we're recording this will air probably in 5 or 6 days from now. Okay. But right now, we've got the Senate and the House debating on new gun control. Let's say what it is. They're calling it School Safety Act, or they're calling it red flag, or calling this and that. It's new gun control.
Bipartisan compromise thing. Yeah, right.
Yeah.
Well, it made it through the Senate, and now it's in the House. It's going to pass the House. It's going to pass. The weird part is, and it makes, I say this carefully because a lot of our hardcore people just start screaming traitor and everything else. There are actually some good things in this bill. There are. There are some things about straw man sales. We always talk about straw sales, and they're illegal, except that there's no penalties. Did you know that? There's no penalty for a straw man sale.
Really?
There's a penalty for forging or not filling out the 4473 correctly.
Okay.
So this would put a penalty in and say, okay, this is a straw sale. You're trying to get a gun to a criminal. Let's have a penalty there. That's in the bill. You go, okay.
Okay.
There's some things about mental health that are in there. There's some mental, but on the other hand, the really horrible thing is the red flag laws, so-called red flag laws. And this would provide funding for states to help them with the red flag laws, where the government can come take your guns away. The problem there inherently is there's no due process.
Right.
If there was due process, I could make the argument that there could be some situations where you say, okay, we all know this person is wingnut, crazy, and dangerous. We need to do something about it. But you can't have an Amber Heard, doing a Johnny Depp on people, making a complaint, and then people come and kick in the door. I mean, literally kick in the door with guns up and taking your guns. If they say, okay, in order to do this, you have to have an opportunity to go to court. You have to have an opportunity to appear before a judge. You have to have the opportunity to have a lawyer to present your case. And then if both sides present their case and the judge says, okay, we're going to do this, we're going to take the guns away. That's one thing. And then part and parcel of that is, and then after a hearing or a trial or whatever, you need to have a way to get your guns back inexpensively and quickly, plus have a provision in there that whichever police department took the guns is legally, financially liable for any damage done to them.
Right. Well, the politicians pass things, and then we'll figure out how to implement it later.
Yeah, except that in this case, they don't want to. So because if for nothing else, because of that one thing with red flag laws, the National Shooting Sports Foundation, which looked at it and said, look, there's some pretty good things here for gun stores. They're going to help them out, but we can't get behind it. With the red flag thing you have in there, we're out. We cannot support this at all. And so it's going through. There are some Republicans who have supported it and will support it. I think woe unto them at election time. Some are not, about half of them are actually not running for re-election. They're just going, this is my swan song, I'm out. And then the others are going, I think I need to do this to appear to have been doing something, not doing something, but just to appear to have done something.
Yeah. And the problem is, I get what you're saying, that there probably are certain aspects to the bill that are good or and they're really maybe even not really related to the gun side of things, but we have a real hard time giving up any ground when it comes to our rights, because we don't ever get them back.
Well, that's it. It's always a one-way movement. Although I keep going back to the Bruen decision is going to restore a lot of our rights. And I remember Alan Gottlieb at the Second Amendment Foundation, his slogan is, winning back gun rights one lawsuit at a time.
That's what they do.
And then
that's what they do.
This Sunday on the radio show, I've got when this news broke yesterday, we said, all right, kick everybody off the show that's scheduled for Sunday.
Right.
We'll reschedule them. We built an all-star team of people coming in to talk about this. And part of that is I'm going to talk about the 40-year process of how we got here. Started with an article by Don Cates, University of Michigan, I believe it was, Law Journal in 1983. And then a whole series of Law Journal articles and decisions and movement. This thing is 40 years in the making by people who had the vision back then to say, we can't start undoing this until we lay the groundwork. They changed the terrain that we're fighting on. And yesterday's decision puts us on the high ground for all the oncoming battles.
It's a really big deal. And I appreciate you coming on and kind of filling us in. And because, some of us, we've got jobs, Tom. We can't just sit around and just read.
I have no life. This is what I do.
We appreciate that. Well, thanks for being on with us, and can't wait to hear the radio show this week. And you guys, thanks for listening, and be sure to stay tuned in and plugged in and stay in touch with those representatives that are representing you.